Hello, everyone, and welcome. My name is Kevin Swain, and I'm the student president for the William F. Buckley Jr. program at Yale. Before I introduce our moderator today, a quick word about us. The mission of the Buckley program is to promote intellectual diversity on Yale's campus. We accomplish this goal in a variety of ways, including speaker series, firing line debates, conferences, seminars, and summer internships for Yale students. Some of our past guests have included Ben Sass, Mitch Daniels, Ian Hersey Ali, Larry Kudlow, and Henry Kissinger, among others. We hope you visit our website at buckleyprogram.com to learn more. And if you are a Yale student who has not yet applied to be a student fellow, we hope you do that as well. Now to introduce our moderator, who will in turn introduce our guest. Akhil Reed Amar is the Sterling Professor of Law and Political Science at Yale University, where he teaches constitutional law in both Yale College and Yale Law School. His work has won awards from both the American Bar Association and the Federalist Society, and has been cited by Supreme Court justices across the spectrum in more than 36 cases. Some of his recent books include America's Unwritten Constitution and The Constitution Today, and he is Yale's only currently active professor to have won the university's unofficial Triple Crown, the Sterling Chair for Scholarship, the Devane Medal for Teaching, and the Lamar Award for Alumni Service. So let's give a warm welcome to our moderator and our guest.
Well, it's such a privilege to be with you all. Thank you for coming, and a special privilege to be able to welcome back to campus my dear friend Ken Starr and his spouse Alice. We're going to talk about Ken Starr's very distinguished career of public service. I'm going to ask him questions about that career. I'm just going to have him kind of walk us through his career, and then we're going to give you all a chance to ask some questions. Do we have the index cards?
Yeah, if you've written a question on your index card, you can just pass them forward.
So there'll be time to hear from you all, but let me, since I'm going to ask him a lot of questions that are rather impersonal about his career in public service, let me just begin on a very personal note to tell you about the Ken Starr that you might not know if you just surf the internet or read newspapers or watch television. Ken and Alice have really become extremely close friends of the Amar family. And I just want to tell you 3 stories about Ken the person. This is going to sound very odd, Ken, but when I think about the people who are absolutely the closest to me in my life, you actually pop up. When I think about my son, when I think about my wife, when I think about my mom, when I think about my best friend and roommate from law school who was a college friend. So here are the stories. So the first time Ken came to the Yale campus at my invitation, it was a miserable weather day. Of course, we never have those here in New Haven, but he came anyway, and at his really no honorarium, just as an accommodation, as an act of friendship. To talk with my students, and we were waiting, I think, for a cab that was going to have to take him to Hartford, and hoping that his plane would get out. It was a miserable, snowy day, and I was just sharing with him a little bit that we had been, Vinitha and I had been through quite a lot of medical issues, and we were hoping to have kids, but we had gone through just an awful lot of heartache and setback, and he just gave me he reached out and gave me a few words of pastoral encouragement, told me he would, he and Alice would be keeping us in, Vinitha and me, in their prayers. And all I can report to you is that the very next month we got pregnant, and that's my son Vic, who's just turned 20 last week and is a first year here at Yale. And so when I think about Vic and I think about Vinitha, I think, you know, who knows why things happen, but I bet those prayers did not hurt. And then I'm a visiting professor at Pepperdine, where Ken Starr is dean of the law school, and a book comes out. It's 2005, America's Constitution, a biography, and he gives the most generous introduction to this book. We did a big book event, and it's sometimes said about a generous introduction, the speaker, after being introduced, sort of very modestly says something, yeah, my mom would have believed that. My mom was actually in the audience that day. She came down just for that event, and she did believe it. Okay, so when I think of my mom, and I think about how you made me look good in front of my mom, and thank you for that. And they send their very warm regards.
Beautiful family.
Here's the final story. I just traded emails earlier today with one of my closest friends from Yale College, who was also my law school roommate, Sam Zurier. Now, I've never tried a case in my life. I'm just a professor, but I had one opportunity to argue a case before the court of history. We were arguing up at Harvard. We were re-arguing in front of the court of history the Dred Scott case, and whether it was rightly decided or not. And my co-counsel was Ken Starr, former Solicitor General of the United States, one of the great oral advocates, of our era. And so, wow, this was a lot of fun. Steve Breyer came up from Washington, D.C. to preside. And my law school roommate's parents just show up. They saw that, I guess it read the publicity and came up. And I introduced the Zuriers to Ken, he's such a people person. He's so warm. He says, Zurier. He says, I wonder if there's any relation to a fellow named Sam Zurier. Sam Zurier applied for a clerkship with me many, many years ago, and I've always remembered this name because his was the most impressive resume I had ever encountered. Now, of course, Sam was my roommate, and Sam, has a Jewish mom who, is now hearing her son praised to the skies by this fellow who 15 years later actually remembers the name of this person because he's actually a generous soul who remembers other people and remembers generous, flattering things about other people. And I just traded emails with Sam this morning, and he wants me to say hi to you. So 3 stories about the people closest in my life: my son, my spouse, my mom, my best buddy from law school, and Ken pops up in the middle of these stories, and that just seems like an interesting pattern that I want to share with you all. Okay.
Like Waldo.
Yeah. Well,
he's there again.
And that's now what I want to pursue about your professional career, because you just keep popping up again and again, maybe Zelig-like even, in the most interesting places. So let's maybe begin the story of your public service, which has especially closely intertwined with the judiciary. Let's begin the story with your apprenticeship in the judiciary itself. You graduate from law school, and then you do this thing called a clerkship, or actually a couple of clerkships. So tell us what a clerkship is, and tell us about your apprenticeship in the judiciary.
Good, thank you. Well, and let me say thank you to this wonderful group. I'm so old, I knew Bill Buckley well. And I even knew Priscilla Buckley, and Alice and I love them both. They're two, almost everyone is here. I'm just going to say everyone is here, is too young to remember, but I heard the term firing line. As a kid, I loved watching Bill Buckley. And talk about the idea of robust but polite debate with his clipboard, and he would have someone with whom he totally disagreed on economics. John Kenneth Galbraith, people, who's that? But very much we would say now a progressive economist, and Bill Buckley was a free market, reasonable regulation and so forth, but liberty is the baseline, et cetera. And definitely non-Keynesian. He would not agree with Richard Nixon that we're all Keynesians now. So excuse me, you haven't talked to Bill Buckley lately, Mr. President. So in any event, thank you for continuing to lift up the distinguished, really unquenchable memory of a man who just loved ideas and was just extraordinary and a polymath. He had so many interests. There was nothing which seemed to escape his interest and on which he was did not write. I mean, he had a certain Churchillian quality in that he never was called to do the sorts of things that Churchill did, but I can't help but think that Churchill must have lived largely in his mind in terms of being interested in everything and work with the written word and so forth. So in any event, thank you. It's an honor to be here. A law clerk is an assistant to the judge, and he or she should never substitute or try to substitute his or her judgment for that of the judge. It is the judge who is either elected, heaven forbid, or consistent with the Massachusetts Constitution of 1780, which was then brought in, imported into Article 3. Here is the world's living biographer the greatest living biographer of America's Constitution. But I think unless Akhil, and if Akhil corrects me, then I stand or sit corrected. But that insight to have a federal judiciary that was unelected, serving during good behavior, as the constitutional text says, was a best practice, as we would say now, from the 13 colonies that said, yes, Mr. Adams, John, was onto something when he was the key architect of the Massachusetts Constitution of 1780. Including the ideas of separation of powers articulated in the text of that Constitution and so forth. So the job of the law clerk, which is a relatively recent innovation. John Marshall, the great Chief Justice, did not have law clerks, right? So you start thinking of the great justices. Let's think of a transitional justice sort of after the Civil War. Stephen Field, very scholarly, did not have law clerks. It was really a 20th century innovation, but it was such a wonderful thing as law's province or domain is expanding that the justices needed help and the judges need help. So you're to help. Now, how do you help? You're really to help, as I see it, Akhil, clerk for Stephen Breyer, so correct me if I'm wrong about this, but I think you will agree. You're there to assist the judge in coming to a judgment with integrity. What is the better answer, the best answer to this particular case? You have two sides, and at the appellate level, someone obviously is lost. Perhaps they're both partial winners, partial losers, but let's just take the simple case. You have winners and you have losers. So you want to be very professional, make sure that you understand, okay, there's a process here. There's a jury trial or a bench trial. Are we to, I looked at the record, I don't think that witness is particularly credible. Oh, really? Is that your job as the appellate judge to reweigh and refine the credibility? Or more generally, what is the standard of review? We have a judgment. How are we going to approach that judgment? So you're to be a very fine, principled lawyer, simply giving the judge your best judgment on how the case should be resolved. And then to assist the judge. Some judges, most these days, do look to the law clerks, and there's a lot of discussion about this, to draft drafts of opinions. And to jump ahead, when I was a judge, I agreed with that, but I also wanted to draft some of my own opinions. I felt it was important for a judge to be a draftsperson himself or herself, not always look to law clerks to do draft one. Nothing wrong with that. I'm not suggesting anything odd, unquestionable, much less unorthodox about it, because it's not unorthodox at all. But I felt it important for the craft to actually do a lot of the initial drafting myself, but then in humility to have my law clerks serve as editors of the drafts that I produce. You're there to help the judge above all at a moral level, not to substitute or to seek to substitute your judgment for that of the judge.
So before we get to your own days as a judge, tell us about especially your apprenticeship at the Supreme Court, an institution that would intertwine with your life forever after. But tell us about the apprenticeship with the Chief Justice, Warren Burger.
Well, I felt very blessed. It was as if lightning had struck or prayers had been answered, because I very much wanted to have that opportunity. But I did not go to the Yale Law School or the Harvard Law School, and I didn't clerk for what is called a feeder judge. Certain judges who are known to be sort of a railroad, as it were, a conduit to a Supreme Court justice. And I didn't have a feeder professor, here's one right here, writing the critical letter of recommendation. So what, if anything, did I have going for me other than God's good grace? And what I had was my judge. I decided early on in my clerkship that I needed to learn the craft, that I should not be presumptuous, and say, hey, judge, and I clerked for a wonderful judge, as Alice will attest, great judge of the United States Court of Appeals for the Fifth Circuit, back during days when desegregation cases were still very hard-fought cases.
And your judge's name?
David Dyer. So he's not in the list of the pantheon of great judges, but appointed by John Kennedy, elevated by LBJ, and totally non-political. Just what's the right answer? And I was to say humiliated. He would never humiliate a law clerk, but I was humbled by being in the presence of someone who was so good at his craft. He had been a superb trial lawyer and was at the top of his game when JFK appointed him to the district bench of the Southern District of Florida. And he had a slew of clients. If you said, oh, that sounds like boring corporate law, but Pan American Airways. Does anyone remember Pan American Airways? I see 3 hands went up. 4 or 5, we're up to 5. So I could go on. The railroad, the great railroad that the Flagler, right? It starts the railroad in Florida, which made Florida. So he was the sort of premier corporate defense lawyer, and he tried cases. Now, the relevance of that is when at the end of the clerkship, I've worked very hard for him, really hard. And I did my very best. So I go into him in humility and say, Judge, Alice, I'm going to California. I'd already taken the California bar. We'd intended to and did go to California. But I've said, I've decided to apply for a Supreme Court clerkship 1 year hence, and I wondered if you would be willing to write a letter of recommendation on my behalf. And he said, I'll call Lewis Powell. Lewis was not only the circuit justice for the Fifth Circuit, so they would hang out together at conferences, but Lewis Powell, during his days as a lawyer, was Richmond's counterpart to David Dyer. And they had co-tried a very complex case for the railroad. So the railroad was a common client, and they had co-chaired, or whatever, the very complex trial, which had turned out well. They became fast friends. So he called Lewis. So I go up, and Alice will remember this, I go up to Richmond to Summer Chambers, where Justice Powell was sitting. And I'd never met him before, but he was extraordinarily gracious and kind and so forth. And he looks at the resume, but he notes above all, the resume was just a pretty good, but not great resume. But he says, I see you published an article while you were, and I think there's a lesson in this, while you were clerking, you just published it in the NYU Law Review? And I said, yes, I had the judge's blessing. I was very interested. It's on judicial power, right in our sweet spot, right? And whether federal judges have the power as an equitable remedy to overturn an election. Boy, this is sounding more familiar, isn't it? Oh, wow. And it wasn't that I had any crystal ball at all. It's just there was an issue that we had worked on in bank, and I was assisting the judge, and I said, Judge, I'm really interested in this, and do you mind if I try to do a law review article? It was accepted by the Harvard Law Review as part of their election law thing, but they'd tear it apart and say, we'll give you footnote credits. You know, Harvard is Harvard. Need I say more? Yale didn't respond. The Yale Law Journal.
I wasn't there then.
You have quality standards at the Yale Law Journal. But NYU said, hey, this is really good, and we accept it. So we're back in the, he looks at that, and he gloms onto that. Now, this is the hard work dimension. You know, what's Thomas Alva? Here's a genius, and there's no, but, you know, what is it, 90% perspiration? So the hard work of doing that was so impressive. Well, Lewis did not hire me because he only hired the best and the brightest, and that was not me. But he called Chief Justice Berger. That's not funny. And so it was a hand-me-down. So I was not good enough, and I really mean this, because then I worked with his law clerks when I arrived at the court. I said, boy, they're really good. I would be unworthy to be in those chambers, but I was good enough for the chief. So I worked very hard with the chief. I don't think I was particularly good the first year. So much to learn at the Supreme Court of the United States. There's just so much to learn in any profession, an engineer, whatever it is. There's just a lot to learn. And the Supreme Court has its own arcane practices, procedures, and so forth, as well as you're dealing with these very important issues, an enormous volume of work because of cert petitions. You probably, as undergraduates, have heard about cert petitions. And they come at you, I mean, just with unremitting furor. And we would do those memos, we call them cert memos. Took an enormous amount of time. So you were working hard, working really hard. And I needed to work extra hard. So the great honor was when Chief Justice Berger, at the end of the clerkship, Alice got a job at Georgetown that required her to stay in Washington, D.C., make a 2-year commitment, moral commitment. So we said, yeah, let's do that, as opposed to heading back to California. And so he asked me to stay on a second year. And I've shared this with Akhil before. I think 1-year clerkships, which is the standard, very understandable. It's great for the law students. More people get to clerk that way. But it's rather sacrificial for the judges and the justices. A lot of district court judges will have a 2-year clerkship, sometimes on the Court of Appeals. But at the Supreme Court, it's usually just 1 year and then you're gone. And that's still the rule, isn't it? I mean, that's still the practice for most.
But he asked you to stay a second year.
I was asked to stay a second year, and it was the second year that I think I was really helpful to the chief. One quick story. The chief was criticized. We all get criticized in public life. But he was criticized within the court.
Not you.
You know, they're an exception to every... And he was criticized for taking all the great cases for himself, so sort of being a hog, right? So here are the yummy cases. And believe it or not, the Supreme Court does not take all great blockbuster cases. Shall New York Times versus Sullivan be overruled, right? Justice Thomas, right? Gosh, that would be an interesting issue to work on. Well, a lot of the cases are statutory interpretation, so the court has to try to do its best to maintain uniformity in federal law. So in any event, we had a securities law case which was high profile, very much in the business community, but otherwise, unless it's the Wall Street Journal, maybe the business section of the New York Times, would not go noticed. But I saw this is a high stakes case. So I said to the Chief Justice, it's going to be in the October term of my second term, knowing this criticism, I said to the Chief before the oral argument, I had a feeling I knew the way it would come out. I was frequently wrong, but this time I got it right. And I said, and if you're in the majority and you assign the opinion, I would love to work with you on this opinion. Well, the Chief was very wise Midwesterner. And I think the case may have even been unanimous. I forget that. But the chief was in the majority, and so he assigned it to himself. And there was sort of, the chief assigns this, and I hate to say this because we have a wonderful friend here, our canine brother or sister. We have a dog here.
But that's what they call the less glamorous
The
cases.
less glamorous cases are called, let's call them cats. But they call them the dogs. And said, well, this is kind of super dog, right? Very complex and so forth. But I felt that's my example of I was able to assist the chief more because I knew the court, knew the backbiting, and knew, well, here's a way that we can show that, he's willing to roll up his sleeves, which he did.
So at the end of that year, how old are you? The end of your second
27.
You're 27. Now, 10 years later, you're going to be nominated and confirmed to be a judge
Terrible.
On the second highest court in the land, the D.C. Circuit. Have I got my basic math about right?
Yeah.
9
36,
years. Okay.
yeah.
Okay. I shortchanged them a year.
Alice has the
okay.
calendar,
And because you're not, but you know, and I didn't look it up. How many judges in the 20th century have been nominated at that young an age to that high a court? Maybe 3 or 4?
On that court, he was the first.
He was the youngest? Okay. The youngest on the D.C. Circuit, the second highest court in the land, a court that has is the traditional launching pad for the Supreme Court. Justice Kavanaugh was on that circuit, so was Justice Thomas, so was Elena Kagan, so was John Roberts, et cetera, et cetera. So just quickly, because I want to focus on some, because we haven't even got to some of the other interesting gigs that you've had. But
I'm filibustering, as you can tell.
so tell us quickly what you did in those 10 years to go from super clerk of the chief to the D.C. Circuit.
Well, again, it was not on the basis of merit, that's for sure. But I was serving.
9 years.
I was serving as I'd become a partner in my law firm, and so that was good. But so what? And then, with the Reagan election, one of my senior partners with whom I worked became the Attorney General of the United States. So you see, it was entirely a merit appointment.
This is William French
So
Smith.
William French Smith, a very elegant lawyer from Boston, but made his professional career in California. And he was he was Ronald Reagan's personal lawyer. That having been said, he was one of the most senior partners of Gibson, Dunn & Crutcher, which is to this day one of the great law firms in the world. And he was the head of the Labor Department, which means, and I can attest to this, he dealt with some pretty tough people. He was on the management side. So, and I met some of the people on the other side who really respected him. I remember this Teamster coming in. Teamster said, I'm going to get killed, into the Justice Department. And he was, is Bill here? And I thought, uh-oh, we got a problem. I said, well, the Attorney General is whatever. And he said, well, tell Bill hello. I'm so-and-so. Well, it turned out that he had been a labor negotiator for the union across the table from Bill Smith. So he had that kind of tough sort of practice, difficult practice. But he became the Attorney General for Ronald Reagan, and he asked me to serve as his chief of staff. So I was beautifully positioned in when vacancies occur on courts to be tapped. I'm going to skip over the Fourth Circuit. That was a signal to Alice. She said, you didn't mention the Fourth Circuit. But that'll be an intentional thing. And so I go on, and you identified absolutely accurately, as you always are, some of the folks on the court. The folks on the court, because I'm so old, who were there when I arrived are Ruth Bader Ginsburg, Robert Bork, formerly of this faculty, Antonin Scalia, and then some of the great lions of the 20th century after World War II, including David Bazelon, who was this iconic figure in American law at the time, appointed by Harry Truman. Everybody's like, you're really old.
Now, you mentioned John Adams, and you've got tenure for good behavior, for life. And this is a launching pad to the Supreme Court, and you're very well respected by your colleagues, by the bar, by the academy. Why the heck would you ever leave that gig?
And I did not want to leave, but then when President Bush 41 was elected, I'm serving on the Court of Appeals, and I was very happy. We had a wonderful life, not making much money as a public servant, but
say that again,
living.
because they actually need to hear
Yeah.
that the odds of getting on the Supreme Court for most people are pretty remote. D.C. Circuit's a little different. These are people who have been partners at major law firms. There are lots of things that they could do that would be quite remunerative, and they give these things up to be, in your word, humble public servants.
Well,
Okay?
it's really in the great traditions of this law school, which sends, needless to say, many of its alums, and now of the college, many of its alums into public service. And so there is, as the economists say, an opportunity cost. But in any event, I was very fulfilled on the court. We ended up having 3 children. We were very blessed by the children. We seemed to be, I was teaching Sunday school, I was coaching Little League, and so forth, and life was good. And Alice had her own career, which was a very successful career as well, very involved in the community. So it was a very well-rounded life. And then the call comes with the new administration, the incoming Bush administration. President Bush had been a vice president. I'm talking about President Bush 41.
George Herbert Walker Bush.
Right. Another Yale man had been vice president of the United States under Ronald Reagan. Happily, I had known him, Akhil, because I'm from Texas originally. I had known him since his earliest days in the United States House of Representatives when he was a Republican congressman from Houston. And we weren't intimate by any means, but we knew one another. So the call comes from the Attorney General of the United States, from his office, and I have 2 meetings at my chambers, and I said no. And it wasn't an offer, it was, would you be willing to be considered? And I said no.
For what? I'm not sure we told them. Why?
Oh, Solicitor General, I'm sorry.
And who's this? What is the Solicitor General?
Right, we need to get this out, don't we? The Solicitor General of the United States is the top advocate for the United States government, an officer of the Justice Department, who argues cases day in and day out in the Supreme Court of the United States, and who has other functions as well, but that's the most visible.
So the government spokesperson at the Supreme Court, sometimes referred to as a 10th justice, with an office both in the executive, the old executive office building, near the White House.
In the Justice Department.
In the Justice Department, okay. And also a second office in the Supreme Court building itself.
Yeah.
People who have done this in the past include people like Robert Bork and Thurgood Marshall and Robert Jackson and Elena Kagan and lots and lots of others.
And then John Roberts really counts because John, who was such a Chief Justice Roberts,
he was acting under you. You gave him a case or two when you recused yourself.
Was the Chief Deputy Solicitor General.
Yeah, so he was your assistant. So it's a pretty good gig.
It's a wonderful gig.
It's often itself a launching pad to the Supreme Court, but you had a good job.
I had a wonderful job.
With life tenure.
With life tenure, and my late father, really couldn't understand it because I took a pay cut. And I wasn't that generously paid to begin with as a judge, and judges should not be that generously paid. They should be fairly paid. And so I take
now,
a
in my
pay
family,
cut.
the harder one to convince wouldn't be my father-in-law, it'd be my spouse.
Well, Alice is very supportive. She had, as I say, her own career, so she was an income producer as well as a great mom. So I said no twice, and then I'm called over. It's clear they're really pushing me pretty hard. And in the Attorney General's office, and I knew that office well because I'd been Chief of Staff to his predecessor, and the Attorney General at this time, again, some older folks will know who I'm talking about. It was former Governor of Pennsylvania, Dick Thornburgh. I was serving as
another Yale man.
That's right, another Yale man. And he had been a great governor, and he had loved being Attorney General. But the politicos in the White House said, you need to resign as Attorney General and run for the United States Senate against a really weak candidate. I forget how Horace Wofford was elected to the United States Senate, but he was not...
Another Yale man, Yale Law School.
Such a show-off. Such a show. Well, that's it. Need we say more? So Senator Wofford was viewed as very weak, and Thornburg was viewed as, oh, you will mop the floor with him and so forth, because you were twice elected governor, you were a very successful governor, you left with very high favorables and so forth. You've been a perfectly fine Attorney General, but when you get another Attorney General, but not anybody else can unseat Harris Wofford. So Dick Thornburg left and lost. It broke his heart because he really loved being Attorney General. But anyway, I'm getting ahead of the story. So Dick Thornburg was a very persuasive guy and says, we really need you. The president wants you to come over here and so forth. And so I called Alice and said, I think I've got to say yes. And so I called him back. I didn't say yes on the spot. And then, and I told the story to John Paul Stevens, to Justice Stevens, who said, you left the court to, leave the judiciary to go over. It's a great job, but that was, I said, and that's when I told him. I hung up the phone with the Attorney General of the United States, and I went in my little cubbyhole restroom and cried like a baby because I so loved being a judge.
Now, had you argued up to that point any case before the Supreme Court?
No.
And
no.
as SG, how many cases, plus or minus, did you argue?
I've argued a total of 36, 11 in my private lawyer capacity, 25 as a Solicitor General.
Okay.
So you argue a lot. I mean, that's the other side.
And you get to wear a really cool coat.
They need to hear about the cool coat. It's a morning suit. It looks like you're going to a very formal daytime wedding in the olden days.
And the SG is the only person who gets to wear that special suit
yeah,
at
no,
the U.S. Supreme Court.
Well, a former, I hate to keep mentioning Harvard, but there's a hall called Griswold Hall, named after a great man named Erwin Griswold, who was dean of the Harvard Law School for 25 years, who served as Solicitor General under both LBJ and Richard Nixon. Now, that's a neat hat trick. And eventually was replaced by Bob Bork. Yeah. So he would continue, even as a private practitioner with his old law firm, the firm he had started out with in Cleveland, Ohio, Jones Day, Rivas and Pogue at the time. It's now Jones Day. I actually see some heads nodding. And so he went back. Instead of returning to Cambridge, he and Harriet stayed in Washington. He became off counsel to that law firm. And he continued to argue cases and would wear the morning suit. But the rest of us, no, it would be viewed. Who do you think you are?
Now,
Dean Griswold was there. He had taught many of the justices, and he knew their resumes and he knew their GPAs at the Harvard Law School.
So in the SG's office, there's this fellow who works under you. Maybe you hired him, named John Roberts?
Yeah.
Uh-huh.
Yeah, because John, to go back when I was Chief of Staff to the Attorney General, so this just goes to show relationships count. I got a phone call from then Associate Attorney General Bill Rehnquist, who I knew from the clerking. By the way, he had told me no too, so I got many no, no, I do not want you to clerk for me, please go away. But I got one, and that's all it took. But anyway, so, and Chief Justice Rehnquist was so informal, and I'm told, because we had assistants answering the phones, I'm in the AG's office, the Attorney General's office, they said, it's Justice Rehnquist. So I pick up the phone and say, Your Honor, he said, hey, Ken, Bill Rehnquist here. I've got a guy. So John Roberts had been clerking
for William Rehnquist.
So get a clerkship. You future lawyers, get a clerkship. You never know what's going to happen.
We call it the judicialization of the judiciary, right? You move up within the judiciary itself.
This is something that Professor Amar came up with very acutely.
And talked about at Pepperdine, yes.
Yeah.
Okay.
Because there used to be politicians on the Supreme Court. There are no politicians. You would say, oh, it's a very political institution. That's a nice suggestion for political science and for law school discussion. But when you look at their backgrounds, we have now had the complete judicialization.
8 of the 9 of them were sitting Federal Court of Appeals judges at the time of appointment. The 9th was former Solicitor General Elena Kagan, which is like a 10th justice. It's a judicial position. Most of them began their careers, I think 6 of the 9, as law clerks. And Brett Kavanaugh, who hasn't come into the story yet, but another person that he's going to hire up a little bit later in the story, I think did 3 clerkships, actually, with Stapleton, Kaczynski, and Kennedy.
What a memory.
No. This guy remembers every single, what's interesting is every single person. He's very much a people person. And so he's always remembering the stories of people. It's just very interesting to observe over the years. Okay.
I learned it from Akhil.
So, okay.
He taught the old man.
You're SG, and you're arguing 24 cases, plus or minus, at the Supreme Court, and you're hiring this young fellow, John Roberts, and you actually even let him be acting SG on something where you've recused yourself.
Right.
Okay. But all good things must end, okay, at a certain point. President Bush is no longer in office. And then what happens?
So I then knew I was going to return to private law practice, and presumably to my old firm, to Gibson, Dunn & Crutcher, which by this point had a Washington, D.C. office. In fact, I had been president at the founding of the Washington office. And so I assumed I'd go back to Gibson Dunn, but for a number of structural reasons, it was not compensation. I decided to launch out, and so 3 of us, with whom I was very close, came as a team, 2 junior people, each very accomplished in his own right, and then yours truly. And so I began as a partner with Kirkland Ellis, Chicago-based, but in the Washington, D.C. office, because at that point, Akhil, they did not have an appellate specialty practice. It was becoming a specialty practice called issues and appeals. Well, that's an interesting issue. That's a tough issue, but it's not on appeal. Bring the issues and appeals lawyers in.
With a special focus, obviously, on the D.C. Circuit and the U.S. Supreme Court, 2 institutions you knew pretty well.
Right. And so I then began adjunct teaching at NYU at that time. One of my pals was John Sexton, dean of the law school, and destined to become president of the university, which, by the way, is another thing. Higher ed needs lawyers. And this is quite apart from Title IX, which we'll probably get to. It needs lawyers. And it's why so many, as you well know, presidents of major universities and then not so major universities are in fact lawyers or legally trained.
So, and that's when actually, because you're also involved in education, I think you and I get to know each other a little bit because of your academic interest. Okay, you have just a stellar reputation across the political spectrum. People like and respect you. You've been a judge, you've been Solicitor General of the United States, an eminent practitioner, and then you take this very, very controversial position as independent counsel, special counsel. What possessed you to do that? Because you were actually basically on the short list to be on the Supreme Court. For any basically Republican administration, your name would have been right at the very tippy top. And this thing was radioactive. A special counsel to investigate the Clinton White House. And I know the answer. I don't know if he's going to tell you the full answer, because he's very modest in some ways. But why would you ever do that?
I was asked.
Yes.
I did not apply. Under the statute that was in...
That was the, yes, because when your country asks you to do something, he actually thinks you should do it. Which is, because it was not the percentage move.
Yeah,
it wasn't.
Yeah, some would say it's a dumb move, and from a personal, because we did go through, the country went through an extremely unpleasant time and the like. And so the family sacrificed, our children sacrificed, Alice certainly sacrificed. But no, I did not apply. In those days, the independent counsel, as I recall, now called special counsel, was appointed by a 3-judge special division of the United States Court of Appeals for the District of Columbia Circuit, the circuit on which I had served. Now this was a
So your former colleagues, in effect, picked you because they knew and respected you.
They had it in for me, I think. I don't know.
Okay.
I must have done something really bad.
And yours truly thinks it was a big mistake to ever have a statute about involving judges picking prosecutors. You eventually, you came to the same view, but that's the law. It's on the books. The Supreme Court has upheld it. So you're just doing what actually your country has asked you to do, right?
This is a very important point for you future members of the House of Representatives, whether it's state, but especially future members of Congress, including the Senate. The old system actually worked. It was ugly, but it's
the old system under, let's say, Richard Nixon and Watergate. This is before this statute.
Yeah.
What was the old system?
It actually worked. The old system was what I call the Grant model, Ulysses S. Grant. The executive branch goes to the outside, so the Ulysses S. Grant model. And happily, Ron Chernow, good Yale man, has vindicated, yet again, Grant's reputation as a person of integrity. Mm-hmm. But he had some pretty naughty people around him.
The credit mobilier scandal and other things.
And other things. And so the thing that launched what I call the Grant model was a scandal involving the Treasury Department, kickbacks and so forth, excise taxes before there was such a thing as an income tax. Can you imagine how the federal government financed its operations? Tariffs, right? Excise taxes, especially we call them sin taxes, right? So whiskey, et cetera. So there were serious allegations of corruption.
In the executive branch itself.
In the executive branch. And Ulysses S. Grant himself made the decision to bring someone in from outside the Justice Department. And so he brought in, and he knew this person, so he was not of Abraham Lincoln's party or Grant's party. He was not from the GOP. He was from the other side of the aisle. John Henderson, a perfectly wonderful, respected United States Senator, a Democrat from Missouri, to investigate a Republican administration. That began the Grant model.
And then Nixon, a Republican, when there are allegations of corruption in his administration, and give me the cards at some point because we can transition to the cards as soon as we talk about his tenure at Independent Counsel.
Oh, good. There are no questions. Thank you all so much.
Nixon.
Just kidding.
When questions arise about corruption in his White House, in his administration, picks his Attorney General, picks someone from the outside, from the other party. He picks someone, named Archibald Cox, who was of the opposition party and former Solicitor General of the United States. So Archibald Cox was very close to the Kennedys, who had run against Richard Nixon, of course. So, but Nixon's administration picks a Solicitor General from the other party, closely associated actually with a candidate that Nixon had run against. Now, the most natural person to have been picked, when there are questions about the Clinton administration, might have been a Solicitor General from the other party, closely associated with someone that actually Clinton ran against, George Herbert Walker Bush. So he is actually the natural person in some ways.
Whose side are you on? No, but that's right. There's the
difference.
The logic.
But the difference is Clinton. And so if we had had the old model, the Grant model, the Nixon model, Clinton might very well have picked you because you were the natural person, but instead you weren't picked that way. And I argue actually it was less good that judges picked you. You would have had more credibility from the beginning if Clinton had been forced to pick someone from the outside like you, because then he couldn't be undercutting you at every moment. But instead, you were picked by, so I'm not on any side, I'm just on the Constitution side, yeah.
No, but that was well said.
But instead, you were picked by
3 judges.
Who were more Republican and your cronies, a critic would say. See, not true, but...
Yeah,
but
the chief judge of that panel
David
was...
Santel.
Right. Was a Republican, and so a conspiracy theory began that this was all a plot to get a Republican activist, namely, even though I was not a Republican activist, to replace, now we haven't talked about Bob Fisk, but that's another Yale man, double Yale. There's a recurring theme here. But by the way, just so you know, lest we not cover the Whitewater, we'll have some questions on it, but the original Whitewater theme.
Well, this is what I want you to tell us. You're picked to be now this special investigator, this special counsel.
And the person who said, I want a, and this is now the Grant model and the Cox model, I want an independent counsel, called that then, to be appointed, was President Clinton. President Clinton directed Janet Reno, the Attorney General, to appoint what we would now call Bob Mueller, a special counsel, totally lost to history, in January of 1994. Why? Because the press is covering the fact that there may have been criminal wrongdoing, there was, in Arkansas in connection with the failure of Madison Guaranty Savings and Loan, a collapsed savings and loan, fraud infected. That's what Whitewater was originally all about. So President Clinton, while traveling internationally, directs the Attorney General appoint, pursuant to what I'm calling the Grant model or the Richard Nixon Cox model, someone to serve in that role. And she did. She appointed a very able person. I don't even know whether I was on the list. I certainly didn't ask to be on any list. And that was Robert Fiske, F-I-S-K-E, senior partner at Davis Polk and Wardwell in New York. Great lawyer, former United States Attorney for the Southern District of New York, very prestigious district. Some of you, if you go to law school, you will end up saying, you know, I think I would like to be an AUSA in the Southern District of New York. It's a great, great way to get terrific experience, serve your country, serve the law, et cetera. So Bob did a fantastic job during his 8 months as the appointed by Janet Reno special counsel, but then, and you may want to move to Congress, then reauthorizes.
Yes, this news. And another special counsel picked by the president on this Grant-Nixon model, I would say in your tradition, is Jack Danforth, Yale Law School graduate, a Republican well respected by the Democrats, former senator from Missouri. But then this statute, which I've always opposed constitutionally, as did Antonin Scalia, as Ken Starr himself would eventually, once he was free to say so, agree, had these constitutional difficulties. Judges shouldn't be appointing prosecutors. It actually undercuts their credibility in various ways, and it violates separation of powers in certain ways. But, okay, your country asks you to do this thing, and you say yes. Now, tell us about, in a nutshell, what you did. And actually, I'm going to ask you a hard question. Tell us about the biggest mistakes you made.
Okay. I assumed that because the Whitewater investment was a failed land deal in Arkansas, that neither the President nor Secretary of State, the future Secretary of State, the then First Lady, made money. In fact, there's no dispute that they lost money. That I would be through with the investigation in 6 months. I didn't know. I was behind the veil of ignorance. So I take the oath of office. I describe this in my book. I take the oath of office in David Santel's chambers. No publicity, no press releases. I just take the oath of office. I literally, I've got my little bag.
Another pay cut, or were you able to keep your...
partial pay cut, yeah, partial pay cut. Because I'm a partner at Kirkland & Ellis, and by the way, paydays in very significant events for private law firms, and Kirkland is a great and very, very productive firm. So I literally go out the courthouse doors where I'd served for those 6 years. I'm now the duly authorized, sworn-in, independent counsel. I go out on Constitution Avenue, Washington, D.C. I hail a cab. There was no Uber, no Lyft. I hail a cab. I go to what was then just called National Airport, now Reagan National Airport. And I hop on a plane and I fly to Little Rock, Arkansas via Memphis. So I get off the plane in Memphis, and I, again, don't know what's going to happen. And I call my law office, my Kirkland office, and my executive assistant says, you have 2 calls to return there. You've had other calls, but you have 2 calls that are very important. One is from Janet Reno, the Attorney General of the United States, and the other is from Lloyd Cutler, Yale man, who was counsel to the President of the United States, to Bill Clinton. And so I take both those calls. I describe these in the book. We don't have time to go into them. I then go on to Little Rock. Bob Fisk, and I described this episode. I was so naive. I really was. And he said, would you like me to send an FBI agent? Well, I'd worked with the FBI, 2 different, and I thought they shouldn't be ferrying people around. I knew they provided that kind of service from time to time, but they should be out solving crimes and chasing the bad guys, et cetera, protecting us and for the counterintelligence, et cetera. So I said, oh, no, I'll just hop in a cab. Big mistake. I hop in a cab. That wasn't a problem. I then get to 2 Financial Center on the west side of Little Rock, and there is a media, what do you call it?
Frenzy.
Frenzy. It was a media frenzy. And I was utterly unprepared. So one of my many big mistakes was I did not see the public relations implications of all this. I just said, I'm a lawyer. I'm going to go do
Had you
a
ever been
lawyer's
a
job.
prosecutor before?
And I'd never been a prosecutor.
See, you're a judge, very
Yeah.
sheltered, and a private. This was a very different job for you.
So that was a huge mistake, one, but I didn't learn from that initial episode that I should have a press spokesperson. I said, no, 6 months. But then as evening, it's still the same day that I've been appointed, as evening is falling on that August day, and we're behind, I see the media is out there. We're on the first floor, and I can tell the media is there. Boy, they're going to stay there? This is not good. So, by the way, Bob didn't have a press spokesman either. And he was a Davis Polk lawyer. You're a lawyer doing a lawyer's job. You don't think about you're running for for office or something. And so happily they went away because we worked on into the night. But as I describe in the book, Bob Fisk says, move your family to Little Rock. You're going to be here a long time. There was criminality afoot in Arkansas. And, now get ready, half of you may want to walk out now, but here was a key thing that showed me this is serious, that implicates the President of the United States himself. And in that initial meeting, he's been implicated in the financial fraud by David Hale, a municipal judge. I describe all this in the book. And we have found Judge Hale credible. He was implicating the President of the United States in federal felony crimes. If that had been all, I said, okay, well, the President's been implicated in a felony. We can handle that. But he also said, and we're also looking into, and there were so many different dimensions of his investigation, including the sitting governor, Jim Guy Tucker, who was eventually indicted and convicted after a jury trial, and who ended up pleading guilty to other felonies as well, in terms of what we just called the cable fraud scam, financial campaign violations by the Clinton campaign in 1990, state violations, but also violations of federal law in terms of the banking, walking around money and so forth. I mean, so there's certain parts of politics that, regardless of your political party, are not very pretty. It's just sort of the boiler room, the underbelly. And so when you get into politics, just say, we got to do it the right way. We're going to comply with every single law, no matter whether we disagree with that law or not. But anyway, so we indicted some bankers in Arkansas. They went into contempt. Susan McDougal, running the savings and loan into the ground, indicted for contempt and so forth. And then The reason that, and this is just unpleasant, but it's just part of our history, the reason that my book is named Contempt is because the Chief Judge of the United States District Court for the Eastern District of Arkansas, Little Rock, held the president in contempt. And he was held in contempt not for perjury, but for obstruction of justice.
But then how does any of that get us to Monica Lewinsky and all of that?
Painful. Well, I was on my way, I thought, to the Pepperdine Law School. We were pretty much all set. We're going to go to Malibu.
Well, you've got like 7 minutes to talk about that, and then I'm going to move to questions.
Okay.
So you're almost done.
So one of the dimensions that I inherited from Bob Fisk was the death investigation of Vincent Foster Jr., who had been Deputy White House Counsel, very close, a law partner of Hillary Rodham Clinton and so forth. And so he had taken his own life. Bob concluded that, but there were many conspiracy theories, including the theory, which was not well-founded, that he had been murdered, his body moved, and so forth. And we undertook to demonstrate that that simply was not so.
So now you're investigating Fostergate.
And the last person to see Vince Foster Jr. alive, at least in the White House complex, was his executive assistant, Linda Tripp, Monica Lewinsky's close friend at the Pentagon. So when years go by, when Linda Tripp calls our office and talks to one of our he was a career prosecutor, Jackie Bennett, great prosecutor from the Public Integrity Section of the Criminal Division of the Justice Department, and says, the president is in the process, there's this unfolding coming out of the Paula Corbin Jones civil case, and I'm being encouraged by this young woman to commit perjury, to file a perjurious affidavit about the president's personal relationships and so forth, and I'm refusing to do it. But you know me, I'm Linda Tripp. I was Vince Foster's executive assistant. So we knew her from that investigation. Jack Bennett did not, but our office, generally speaking, knew her.
Okay, and
we take that, by the way, people say, I do need to add this, and I'm sorry, I know we're running out of time, but this is very important. We take this information, we confirm the information in the famous or infamous Ritz-Carlton episode. We take that information because we've now determined through wiring Linda, which is that's law enforcement 101, you want to make sure you've got the accurate, authentic material. We take that information to Attorney General Janet Reno, and she, to her great credit, determined in about 24 hours, this has to be examined, and Starr, you should do. Now, I think that was
expands your jurisdiction,
and I think
your
that was
mandate.
And I think that was a huge mistake. If you said, what is the biggest mistake? It was a shared mistake from Janet Reno and yours truly, because if in an ideal world, but you'd never live in government as elsewhere in an ideal world, she would have had a ready reservist, independent counsel ready to go.
Number 2, number 3. But you're up and running, and you know some of the cast of characters like Linda Tripp, so in the moment it seemed kind of efficient and sensible to say, you're looking into all these allegations of corruption. In law, we would call that sort of joinder of a certain sort, bringing together against the same defendant different accusations or something. There was a certain idea that that was the efficient thing to do because you're up and running.
Well, and also and I don't mean to be unpleasant here, this institution is very important to both the former president and the former Secretary of State.
Both of whom are Yale Law School graduates.
But we felt both had committed perjury. So we're hearing something that is very consistent with our own opinions. By the way, this is so current now in terms of the Mueller investigation and Michael Cohen. Prosecutors frequently say there's a difference between what I know and what I can prove.
Okay, so that takes us actually, let me use that as a segue. He actually does some interesting things after that, but we can't get into everything. So we're not going to talk about Baylor or Pepperdine or some of the other chapters in a very interesting life. We've been focusing mainly on the public service parts of your career. So here's a question. There are several that I'm just going to go through. Since you just mentioned this about How should we think about investigations of the President of the United States?
I think we should think about them that they're extremely important and we need to protect the prosecutor. So you say, well, easy for you to say that. You felt that you weren't being protected. But we have, Akhil, through our separation of powers system, returned to the regime that made all the sense in the world in terms of accountability, and that is Bob Mueller was appointed by the Attorney General, the acting Attorney General, Rod Rosenstein. That is precisely the Grant methodology, the Nixon methodology. Right. It's the Truman methodology.
What we did with Jack Danforth.
Exactly. It was the Janet Reno with
which was about Waco, the Waco investigation. A claim that the Democratic Attorney General had screwed up, so she arranges for the appointment of a Republican outside to do an investigation of the whole thing.
Right, and that's the way it should have continued. Now, you
alongside congressional oversight with the ever possible option, should it become necessary, of impeachment.
Absolutely.
Right? That's the Nixon model also.
Exactly. The problem, one of the huge problems in that respect with the independent counsel statute is, and this was Scalia's dissent. I really encourage you to read the Scalia dissent in Morrison versus Olson. He analyzed the statute from a constitutional perspective, but the constitutional perspective, what's the context? And he said this case is all about power, and that's what our separation of powers, separation of powers. We don't want too much power accumulated in a single branch. And so part of the Scalia critique of the original independent counsel statute called the Special Prosecutor Provisions of the Ethics in Government Act of 1978 was, this statute is acrid with the smell of impeachment. Mm-hmm. When you look at the statute, you read the statute, and you can have that aha moment. Congress was using a weapon, and President Clinton's very wise first White House counsel before Lloyd Cutler, a very, very smart, savvy, experienced lawyer named Bernie Nussbaum. Bernie Nussbaum said to the president, when this law came before him, Bob Fisk is on the beat in Little Rock, okay? Appointed by the Grant model, the Janet Reno model. And so here comes the statute, and Bernie Nussbaum, counsel to the president, says, Mr. President, do not sign this bill. It is, now I'm paraphrasing, but he used very good New York language without profanity. This is a dagger aimed at the heart of the presidency. Not at your heart, but at the heart of the presidency. This is a congressional weapon to be used against you. Now when you look at part of the statute that required the independent counsel, yours truly, to refer to the House of Representatives when an impeachable offense may have been committed, you say, aha. So that's why we got into the impeachment business there. Now the Reno regulations under which Bob Mueller was appointed, we're waiting for the Bob Mueller, quote, report, but we're probably not going to see a Bob Mueller report because when you go to the text, even as citizens, we go to the text. What are the regulations under which it's written? There is no report to Congress at all. The only report from Bob Mueller is a, quote, confidential report to the Attorney General of the United States.
On the Grant model.
The Grant model,
within the executive branch.
Wise Ulysses.
Okay, we only have about 10 minutes left, so I'm going to try to get in a few more questions here of yours. You and I'm going to try to connect it and rephrase some of these questions. We actually think the text of the Constitution is pretty wise. Mm-hmm. And it doesn't basically provide for judges picking prosecutors. Mm. And it does provide for presidential oversight by Congress, and it provides for impeachment by Congress. So we say stick to that model, right?
Exactly.
Scalia was right. The text was. Now, one person has a hot take. I'll tell you what I think in a second, but this person's hot take is, in order to rein in things like Trump's emergency declaration, we should have a legislative veto scheme, and that Chief Justice Berger's opinion in Chadha is one of his most incorrect. What do you think about that?
With all due respect, I agree with Chief Justice Berger, not because... I'm getting growled at.
And what would our friend Antonin Scalia say about...
Scalia would definitely he would have written a much better majority opinion, if I may say so. Now, I clerked for the late Chief Justice, but...
Because when you look at the text of the Constitution, it doesn't provide for a legislative veto. Constitution rock, there's a bill, it sits on Capitol Hill, and then it has to be passed by the House and the Senate and the President, and that's in the Constitution. Just like it's in the Constitution that presidents should pick people within the executive branch and not judges, and Congress should do the impeaching, and that's the text 101, right?
Exactly. Yes, he is absolutely right. It's 101. And I would also say that during Professor Amar's lifetime, I will probably be gone, and during Alice's lifetime. Oh, I'm getting votes of sympathy over here from my canine friend. What's the dog's name? Titan. Oh, wow, that's great. That is a great name. You will have a serious conversation, we the people, about should we move to a parliamentary system. I predict that. I predict that you will have that serious conversation. Because too many presidents have too many issues, too many flaws. The election of the president, people want a popular plebiscite. They want to ignore Wyoming. They want to ignore Delaware. They just want the president to be decided by New York, California, right? Where we the people, and that's the way it should be, right? If you're going to do that, and the states are on their way to doing that, please start thinking seriously about a parliamentary system. The parliamentary system is pretty darn good. Democracy lives. They don't have quite the robust First Amendment we have, but you can still have the First Amendment and a parliamentary democracy. Now, why do I get off into that? What Morrison v. Olson vindicated was a regime of parliamentary supremacy.
That the majority opinion basically leaned too much in favor of Congress and didn't pay attention to the text of the Constitution. And Antonin Scalia and Ken Starr and yours truly say, actually, let's look carefully at the text of the Constitution.
Now, I like our system, by the way.
Now,
and I'm here to defend the Electoral College.
Two final questions here.
I'm not here to defend.
I got a question about the firing of Jeff Sessions. What does the Constitution say about whether presidents get to fire attorneys general?
At will. For whatever reason, including I do not like the way he talks, right? He's from Southern Alabama. He's from Mobile. I'm from Queens. I've had it. I cannot stand that accent around him any longer, right? And it does not constitute even arguably or colorably, in my view, as obstruction of justice, nor does the firing of James Comey even come close. You'd say, wait. How can you do that? He was trying to interfere with the Russia investigation. That's a fact point. Let's look at it. But under the Supreme Court's authoritative interpretation of a statute, Congress can change this, there has to be a corrupt act. And you said, I don't like the Russia investigation. It's in my way. Boom. I want Comey out of here. Now, if he said, by the way, I want Jim Comey out of here, and by the way, we're not going to provide any funds to this investigation. And by the way, there's some testimony to the fact that, and one of the reasons is my family, blah, 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 blah. You can start seeing, moving into the arena of real corruption as opposed to the exercise, whether wisely or not, of Article II power.
And another way of putting that point is that if I don't like Comey, but I put in place of Comey someone, Yale Law School graduate of distinction, that's my call. I get to pick the people, because that's what the Constitution says.
Yeah.
And is there a political price that I might have to pay if people don't like any of that?
Well, in fact, yes. I mean, you may end up having House investigations, right? Those are underway. So we see the dynamic of the process at work, right? We had a midterm elections, and it went very badly for the president's party, right? So part of that is kind of a referendum on the presidency around the country. People said, no, I think we need to have some divided government. All right, divided government means the minority is going to be very, very vigorous. But you then hold the president accountable. Now, I have been saying, by the way, I said this as recently as Sunday, that it depends on what the House is looking into. But I would say, because this may become a litigable issue, are you actually looking into issues that might pertain to the legislative process or the oversight of government? Because if you're simply looking into possible crimes in business transactions, is it really? And I'm saying it sounds to me as if it's in the nature of, it's not a violation of the text, but it's a violation of the spirit of a bill of attainder. You don't start investigating a person and single out, how many investigations are underway now? 81 investigations. Unless it relates to the government. I think you need a nexus to the government as opposed to, we think that there was fraud and insurance fraud and tax fraud. Tax may be a little closer to a legislative nexus.
But anything connected to the president would be fair game.
As president, do you see what I'm saying? As president would be my view. That is to say, it could very well have been said, what the heck does Whitewater have to do pre-presidential election with the conduct of the presidency? But unfortunately, we had this law that said if federal crimes may have been committed, even though it had nothing to do, the Whitewater land deal and the fraud at Madison Guaranty Savings and Loan and all those crimes had nothing to do with the conduct of the presidency.
Okay, that's one thing that I might disagree with you about, whether Congress should have even broader power. But this is your moment here. So the elephant in the room. The last question, of course, but I only got one question about it. Brett Kavanaugh.
Yeah.
We talked about how you hired up, how Warren Burger hired you, and William French Smith hired you. And in effect, the 3-judge panel, the D.C. Circuit, hired you, and Janet Reno kept giving you, if not promotions, at least more assignments. Okay, but then we've also talked about some of the people that you hired, like John Roberts. Whatever happened to him? But Brett Kavanaugh, someone you hired early on, another Yale College, Yale Law School, on the D.C. Circuit, as you were a judge on the D.C. Circuit, now on the Supreme Court, as you might have been. Can you give us some thoughts about basically the confirmation process? Basically, I'm reworking your question a little bit to connect it to what he's talked about.
Well,
so Brett Kavanaugh and the confirmation process.
Well, your colleague, I would begin by citing a book from long ago by your colleague Stephen Carter. Entitled
Confirmation Mess.
The Confirmation Mess. And he had several confirmation processes in mind. One was of Robert Bork, but another was of Lana Guinier, who was an African-American candidate to become United States Assistant Attorney General for the Civil Rights Division.
Another Yale Law School graduate.
And so without taking a position on the merits, it was just the process. And so I do think that many of his observations about the confirmation mess continue to this day. In terms of Brett, I will say, so this is personal testimony, I worked alongside him year after year after year in the independent counsel's office, in private law practice. Never was there a hint of any kind of impropriety, not a hint, or inappropriate behavior, much less a vicious kind of assault on a precious human being. Nothing remotely like that. So I know him. I never met Dr. Ford. Obviously, I heard her testimony the way the nation heard the testimony. At the end of the day, obviously, I know Brett. I don't know Dr. Ford. But I know Brett to be a person of Justice Kavanaugh, to be a person of complete integrity. When you talk to the people, in fact, I talked to someone recently who is a judge in Portland, Oregon, which is a center of progressivism. And she said she really was shocked that, because she worked alongside Brett Kavanaugh, that this kind of allegation would have been made. She doesn't say it didn't happen. I've never said a bad word against, and I will not today, against Dr. Ford. But knowing Brett, knowing his character, knowing him over many years, I have this theory. Character shows up. It shows up in a person's behavior. You say, well, it was a one-off in high school. But then I start looking, this is where the lawyer in me comes out, and I say, okay, where's the corroboration? We have an allegation. Where's the corroboration? And to my surprise, it really was a surprise, Brett had corroboration, not just an eyewitness. Witnesses sometimes get it wrong. And by the way, if you don't think eyewitnesses get it wrong, sign up for the Innocence Project. When you meet someone who has been on death row, who was falsely not just charged, I'm not accusing anyone of anything, I'm saying this is a fact, falsely, and I mean by that wrongly accused of committing the ultimate kind of crime other than genocide itself, and that's murder, the willful, premeditated taking of life. And it was proven in a court in California that she did it. Thank goodness for DNA. She did not do it. And I am involved in the Innocence Project. Now just say, we need as citizens to be very careful not to rush to judgment, and don't even say, well, an eyewitness saw it, because eyewitnesses, even honest eyewitnesses, sometimes get it wrong. But anyway, the surprising part, on a slightly, what should I say, personal note with Brett, is that he had high school calendars that showed that he wasn't there. So there was no evidence putting him at the party. There was contrary evidence that he was that he was at another party or whatever. There was all the testimony from the young women saying in high school, he never conducted himself this way. This is so unlike Brett. The biggest problem I heard is he does like beer. So stop drinking.
And
by the way, when's happy hour?
just by way of one final note, the Pepperdine campus, where Ken was the law school dean, was formerly a dry campus, just letting you know. And also at Baylor, dry? Okay, so.
But where could you get a good drink? At the Star Speakeasy. At our house on campus, because you see, yeah, the campus, and there's, by the way, there's for those of you who are leaders in your organizations and so forth, I'll tell you, I heard the dean of Northwestern Law School, so we're talking about law school, we're not talking about undergrad, David Vincent, and this is before the Obama administration Title IX guidance and the current kinds of concerns, which are very important concerns for us to focus on, said, if it's an official event, don't serve alcohol. Nothing good will come of it. And this is a law school. So, of course, the students don't always just stay on campus.
Well, with that, please join me in thanking Ken for really an extraordinary